Environmental activists say they want their voices heard as the country's top court considers the future of oil exploration along South Africa's wild coast. They marched outside the Constitutional Court in Johannesburg, protesting over Shell's plan to drill for oil and gas in the area. Activist and leader of Amadiba Crisis Committee, Nontle Mbutuma, says coastal communities have been sidelined in decisions that directly affect their livelihoods and the environment.
Now, if our government and also Shell, they must listen to the people on the ground, because here we're dependent from the ocean. Once you do oil and gas, that means there will be no livelihood for us. Why we need to compromise our livelihood for short term? Whereas we do have alternative, which is agriculture, which is tourism, that it can sustain our communities for a longer time than the oil and gas. Oil and gas, also we said that oil and gas is the most culprit that is contributing to the climate change that is affecting us as people that we are living on the ground. Now, our government cannot continue to grant more licenses of mining. That's what we are here today, to tell them that they must stop, continue to applying more licenses.
Arguing on behalf of the communities, advocate Tembeka Ngwaitobi says the SCA ruling effectively gives Shell a second chance to fix a fatally flawed consultation process, something they argue the law does not permit.
Shell wants to keep the spoils of an unlawful process. Now, in a tender context, no party is entitled to retain the spoils of an unlawful process. There is, in fact, a no-benefit principle coming all the way from all pay. You are not entitled to benefit from an unconstitutional process. This is precisely what Shell is trying to do, is trying to benefit from an unlawful process.
Meanwhile, fighting to retain the exploration block, Council for Impact Africa, Chris Loxton, told the court it would not be desirable for the right to be lost completely.
Our submission, in short, is that it's never an easy thing in these particular circumstances to reach the balance. It's a messy process. There will always be questions which arise as to whether the right balance or the right process was adopted. But we say that the Supreme Court of Appeal did get it right, and we would submit that the decision ought not to be set aside.
The Apex Court's judgment will set an important legal precedent on seismic surveys in the country. Nosipukhatebe, SABC News, Johannesburg.